Good morning, everybody. Happy Friday Eve. It's a Thursday here on TCF Live. My name is Dan Soul. I'll be your guide in the next 3-hour journey through Courtlandia. We're going to get started with Michael Olsaver in Lenawee County, Michigan.
Day for sentencing in this case, and we are proceeding today partially in person and partially by video conference. I do have one person, Samantha Moore, where it is I think going to make a big impact statement, who's attending by Zoom. I do have Ms. Moore in the Zoom session now. So can I have the attorneys place their appearances on the record?
Jennifer Bruggeman on behalf of the people.
Good morning, Your Honor. Allison Swain from the State Appellate Defender's Office on behalf of Marshall Sosby. Marshall Sosby is here in person today.
And sir, you are Marshall Scott Sosby.
Yes, Your Honor.
Mr. Sosby, have you had an opportunity to read and review the pre-sentence report and the updates to the pre-sentence report?
Yes, Your Honor.
Have you had an opportunity to discuss those reports with your attorney?
Yes, Your Honor.
Wish to explain or challenge the accuracy or relevancy of any of the information that is in these reports?
No, everything's good. Thank you.
I'm sorry to interrupt. I just want to make sure that Ms. Moore is let in. She wanted to be present for the entire sentence.
She is in session.
Okay,
She doesn't have her camera on, so
I see. Okay.
so you're not going to see her up there, but she her device is in the Zoom session and her audio is connected.
Okay, thank you.
The pre-sentence report did not disclose any prior convictions, any with a known constitutional defect. And sentencing guidelines in this case are calculated 225 to 375 months. Ms. Brookman, do you agree with that computation of the guidelines?
I agree with the totals, Your Honor, but as I indicated in my sentencing memorandum, I do believe that OB3 should be scored at 25 points. That doesn't affect the guideline minimum range, but I do believe that that would be appropriate, given that we can't score 100 points since this is a homicide offense, but under People v. Houston, which I cited in my sentencing memorandum, that at 25 points is appropriate in instances when a victim is killed. And we have 2 victims here, but I do believe that 25 points is appropriate, and I would like that to be scored. It's currently scored at 0.
Ms. Swain?
Your Honor, I believe given that it doesn't change the range of the sentencing guidelines, we have no objection at this time for that.
All right, 25 points is appropriate under OV3 where there was life-threatening permanent incapacity that occurred to a victim. People cite People versus Houston, 473, Michigan, 399, 2005 case for the proposition of scoring 25 points for life-threatening permanent incapacitating injury was proper in a second-degree murder, even though the victim was killed. So it does appear appropriate to score 25 points. Will be 3. That does not change the minimum guideline range because we were already at the maximum minimum guideline range, and so it remained at 225 to 375. Any other issues with the guidelines, Ms.
No, Your Honor, thank you.
Does the defense have any guideline challenges?
No, Your Honor.
Before the court passes sentence, then Ms. Swain, is there anything you want to say on behalf of Mr. Sosby?
Yes, Your Honor. I first want to take a moment to acknowledge the tremendous loss that the Sosby family and so many others experienced by losing their loved ones, Carmen and Michael Sosby. Marshall's actions killing his parents were senseless. His siblings should have never had to endure that loss at such a young age, and his grandparents should not have had to have buried their children. We're here today because the Michigan Supreme Court held in People v. Stovall that a life with parole sentence for an offense committed by a child violates the Michigan Constitution's prohibition on cruel or unusual punishment. At the time of this offense, Marshall was 17 years old. He was a scared, immature, and impetuous kid. Today, Marshall is 35 years old. He has grown and matured from that abused 17-year-old into a remorseful and thoughtful man. He spent the last 17 years participating in programming, bettering himself and those around him. He spent that time self-reflecting and living with the pain of this offense. When fashioning a new sentence for Marshall, there are many considerations for this court. A sentence must be proportionate to the offense and the offender. People v. Boykin and People v. Eccles require this court to consider the mitigating characteristics of Marshall's youth at the time he committed this offense. Boykin tells us that youth necessarily impacts the analysis of the Snow factors, reformation of the offender, protection of society, and discipline of the wrongdoer. Finally, while this court is not required to make findings as to the Miller factors, the Miller factors inform the analysis of the mitigating characteristics of youth outlined by Boykin. I know I filed a lengthy sentencing memo, so I don't plan to re-argue everything here, but I want to talk a little bit about the relevant Snow factors and Miller factors as they apply to Marshall. I also want to be clear that none of the arguments I make are meant to be excuses for Marshall's horrible actions. Still, Miller requires us to consider what it defined as the mitigating qualities of youth, which include a youthful defendant's background, mental, and emotional development. The first Miller factor is chronological age and its hallmark features of youth. Marshall's chronological age is mitigating. He committed this offense when he was 17 years old. Our case law tells us that youth is always mitigating and must be considered for its mitigating impact. The brain science tells us that adolescents, compared to mature adults, have a reduced ability to control their impulses in a complex or emotionally charged situation. They also have a reduced ability to manage their emotions, and they place more value on the potential benefits of certain behavior rather than fully considering the risks. The inability to recognize certain behaviors or situations as risky or wrong can be exacerbated by early traumatic experiences. Marshall's age alone is mitigating and mitigates in favor of a sentence of 225 months on the homicides. The next Miller factor is the circumstances of the family and home environment. This case is unique because Marshall killed his own parents, who subjected him to extreme abuse and neglect. It may sound like I'm making excuses or justifying their murders, but that's not the purpose of talking about what it was like for Marshall while growing up. The law is clear that this factor is relevant to juveniles' characteristics of youth. Even if Marshall hadn't killed his own parents, what he experienced in his home as a child and growing up is significantly mitigating and would be relevant to this court when crafting a proportionate sentence. Miller tells us that a juvenile's circumstances of the family and home environment are relevant because children are more vulnerable to negative influences, including those from their family. They have limited control of their own environments and lack the ability to extricate themselves from horrific crime-producing settings. Marshall's father was abusive towards Carmen and his children. When Marshall was 3 years old, Michael, his father, knocked him down because Marshall got in the way of him threatening his wife with a machete. Growing up, not only was Marshall unable to extricate himself from his father's horrific abuse, but even his mother was frequently unable to leave and keep her family safe. The abuse was so extreme, Carmen tried to escape her husband's abuse on several occasions, fleeing to different states and even out of the country. Marshall grew up with an emergency backpack, something like his mother also had, in case they needed to escape for safety. Because of her own abuse, Carmen did her best to care for her children, but there were times when she left on her own, leaving Marshall and his siblings behind. On some of these occasions, Michael would have Marshall call his mom and beg her to come back. The escapes were never successful. They always ended up with Marshall's parents getting back together, and the violence would continue. Marshall grew up near his paternal grandparents and who would try to protect the children when they could, but Michael frequently would not let his parents see their grandchildren if they were trying to intervene between him and his wife. As he grew up, Marshall experienced abuse, like his father handcuffing him to his brother, holding him underwater in a pool, using a taser and electric collar on him as punishments. In the year leading up to this offense, Marshall's father, holding a 9mm gun, ordered Marshall outside and to face away from him. Michael shot Marshall in the back, causing him to fall to the ground. It wasn't until his father was standing over him that Marshall realized his father had switched out the Smith & Wesson for a paintball gun. Marshall grew up in tremendous fear of his father. He felt protective of his mother and wanted to help, but he was a child who also needed to be protected. And he was not getting that from the adults in his life. He spent a lot of time alone, retreating to the comfort of video games, fantasy worlds, and online friendships. He experienced things no child should have to experience, especially by the person who is supposed to be his protector. He saw things that no child is supposed to see. What Marshall experienced as a child, both trauma and neglect, mitigates in favor of a sentence of 225 months for the homicides. The next Miller factors are the circumstances of the event and the ability to navigate the criminal justice system. On September 23rd, 2008, Marshall got into a fight with his father about his cell phone and unjustifiably shot and killed his father and his mother. Marshall then threatened his sister Samantha's life when he pointed a gun at her and told her not to tell the police what really happened. He initially denied his actions, lying to police. Following the offense, Marshall was found to be incompetent for trial for a period of time. He was admitted to the Center for Forensic Psychiatry before he was eventually restored to competency. Marshall then pleaded guilty to second-degree murder and apologized, taking accountability for his actions. Today, he takes full responsibility for killing his parents and is incredibly remorseful for the harm he caused his family and other loved ones. While the context of the strained and abusive relationship with his parents is relevant for this court's consideration, Marshall by no means argues that this excuses his behaviors. This court will hear directly from Marshall in his own words about how remorseful he is for the harm he has caused. The final factors are sort of addressed together. The Miller factor is the possibility of rehabilitation, and the Snow factors of reformation of the offender, protection of society, and disciplining the wrongdoer. All of which are mitigating as to a term of 25 months for the homicides. Adolescents grow and change. Case law tells us that rehabilitation involves the successful completion of vocational, educational, or counseling programs designed to enable a prisoner to lead a useful life free of crime when released. That's People v. Bennett. Case law also tells us that the Snow factors must be viewed through the mitigating lens of youth. As to the Snow factor of reformation of the offender, People v. Boykin tells us that, quote, an adolescent's greater possibility that his character deficiencies will be reformed necessarily transforms reformation of the offender, end quote. As to protection of society, Boykin tells us that a youth's heightened capacity for change compared to adults necessarily impacts the consideration of protection of society. When it comes to the Snow factor regarding discipline of the wrongdoer, Boykin tells us it's less supportable to conclude that even a heinous crime committed by a juvenile is evidence of irretrievably depraved character. Finally, as outlined in the sentencing memo, case law tells us that deterrence cannot be measured for the same reasons adolescents are less culpable, they are less likely to consider punishment. All three relevant Snow factors contemplate that adolescents change. Marshall's reformation, rehabilitation, heightened capacity for change, and how he has been adequately disciplined for this offense are all demonstrated through the work he's done when he's been incarcerated for the last 17 years. I want to highlight just a few of his accomplishments over those years and the work that he's put in the last half of his life and why he's deserving of a sentence of 225 months. First, I want to touch on Marshall's MDOC disciplinary record. In 17 years of incarceration, Marshall has incurred only one Class 1 misconduct and only 9 misconduct tickets total. He's been at the lowest security level possible for the last 12 years. His misconduct record is below the average for an incarcerated inmate in Michigan. His record is especially exemplary because we know that juveniles earn a lot of those early misconducts in the first years that they're incarcerated. And not only did Marshall not rack up a bunch of misconducts, he has been consistent over time. Next, I want to talk about Marshall's programming and education. In 2010, he earned his GED in prison. He's currently enrolled in Jackson College and is a member of the Honor Society. Marshall has meaningfully engaged in as much programming as has been available to him. Early on, Marshall sought out involvement in programming to better himself and change his way of thinking. He established himself as a leader and a mentor and became a facilitator for many programs after he took them. There are many letters of support from other incarcerated individuals attached to the pleadings before this court. The list of programming that Marshall has been involved in is extensive and also before this court in the pleadings. Notably, he's participated in programs like Cage Your Rage, effective communication, personal dynamics, healthy relationships, critical thinking, and much more. Marshall has instructed or facilitated programs like critical thinking, conflict resolution, and inside out programs with college students. Most recently, Marshall finished a personal integrity course and earned a 4.0 in his English course. In terms of trades and job readiness for when he comes home, Marshall has participated in study courses like commercial driver's license, advanced business, real estate, small business, and programs like computer science, legal research, Money Start computer-based instruction, and Build Your Own Financial Future. Marshall has also been involved extensively in the Prison for Creative Arts program, also known as PCAP, through the University of Michigan, participating in creative writing and theater. As we think about Marshall's future, he recognizes how lucky he is to have had the support of his grandfather until his grandfather passed last year, and to have the support of his grandmother. Over the years of his incarceration, his grandparents were his biggest supporters. Today, Marshall has a network of people who are ready to support him. His grandma is here today. Many members of the Sato reentry team and Sato are here also to support him. When Marshall is released, he plans to live with his grandmother, or to Marshall, his Oma. Oma is eager to welcome Marshall back into society and has a bedroom set up for him in her home. Marshall also has the support from his brother Tristan, who he has been able to foster a relationship with over these years. He has the support from Sato's Project Reentry and PCAP professor Dr. Ashley Lucas through PCAP's reentry program linkage. In summary, as People v. Milbourne tells us, imposition of the maximum possible sentence in the face of compelling circumstances would run against the concept of proportionality. An analysis of the Snow factors and the Miller factors here demonstrate that a proportionate sentence is 225 months on the homicides. In the majority of cases where an adolescent committed first-degree murder, the sentencing range is 25 to 40 years on the minimum. Marshall took responsibility and pleaded guilty to second-degree murder when he was still a child. Sentencing Marshall to a sentence that is just as harsh or even harsher than the range for first-degree murder juvenile would be disproportionate. Marshall has used each year of his incarceration to better himself and those around him. Just as the law has indicated that he would change, just as the law has indicated he had a greater possibility for reform, he has demonstrated that. It is evidence in his programming, education, and work history. As to deterrence, the case law tells us it's nearly impossible to measure deterrence when it comes to adolescents because the same characteristics that render juveniles less culpable than adults makes them less likely to consider potential punishments. When it comes to protection of society, Marshall has been housed at the lowest level of security available to him for the last 12 years. In 2012, just a few years after arriving to prison, Marshall's risk assessment on a prison evaluation posed such a low risk for violence, MDOC removed him from the waiting list for mandatory violence prevention programming, as he did not need this because of his low risk score. The law tells us he has a heightened capacity for change, and he has changed. As to disciplining the wrongdoer, Marshall has been incarcerated since 2008. His actions are not those of an irretrievably depraved character, but instead a desperate, angry, and abused child. Marshall knows that when he killed his parents, he destroyed his family. In addition to his years incarcerated, Marshall is tormented each day knowing he is the one responsible for taking the lives of his parents. While there is nothing he can do to bring them back, and nothing he can do to heal the wounds he has already caused to his siblings, his grandparents, and the community, Marshall has already dedicated himself to giving back and has no plans to stop once he is home. Where he's availed himself to give to as much programming as possible, mental health treatment, and seen as a mentor, additional incarceration at this point is just that, punishment, and serves no further rehabilitative purpose. The guidelines that govern this case were scored aggressively and reflect the aggravated nature of this crime. Marshall has demonstrated the rehabilitative ideal. For these reasons and the reasons put forth in my sentencing memo and appendix, I'm asking this court to resentence Marshall to 225 months on the homicide offenses.
Thank you. Mr. Sosby, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, John.
I was a horrible person who created a void and destruction within those I loved and cherished and in my community. When I took the lives of my mom, Carmen Sosby, my dad, Michael Sosby, my actions also caused feelings of betrayal. Pain, suffering, anger, and unthinkable fear. This especially was and is felt by Samantha, Devin, Tristan, and the rest of my family. Because of my actions, my siblings needed therapy and support from one another to just handle their daily lives. I don't know what my parents may have felt themselves seeing me, their oldest son, holding a gun pointing it toward them. I imagine Dad felt confusion, rage, and sadness. My mom, her husband killed. I imagine she was overwhelmed with betrayal, grief, sadness, confusion, gut-wrenching pain. Never truly be able to correct what I've taken and the emotions of pain I place on my family, friends of the family, and society on that horrific day. Tristan almost told me about how you took your shoes off and said, "Mama, get at home." On that perfect day, you were so young, and what happened didn't dawn on you. You slowly learned that they were never coming back. I know you were picked on at school because of your parents were dead. Seeing your friends spend time with their families during holidays, when it reopens a wound, you'll never have those moments. You'll never experience having our parents. You've never had a chance to have the conversation you could have had with them. And now you just had a son, and I know your son will never get a chance to know their grandparents. I'm so sorry for making you go through life with shattered pieces and never knowing how to put them back together. Devin, you were always the one with the golden heart who never wanted to hurt anyone's feelings. On that horrific day, you had no idea this would happen. I can only imagine your fear, terror, and confusion as you heard gunshots and saw Dad and Mom die on my hands. You saw how much I love Mom, yet I killed her. You might have thought you were going to die too. I traumatized you. I betrayed you. At times, I wondered if you moved out of state to get away from all of this. I know this is something you don't want to relive, and our parents weren't there to see your accomplishments. They weren't there to see you finish high school, get married, have children, become an amazing dad. In the Navy, become a state trooper, or start your own business. I took that opportunity from you. I caused a tornado that went through. It remains your whole life in a horrible way. I'm sorry. Samantha, I made you feel like you were going to die. I tore your soul apart. I was your reaper. It was like a horror movie for you. You saw me take Dad's life. I was your champion. And then you saw me take the life of Bob, someone I cherished. And you thought you were next because I threatened you. I know this fear that you've been living with your whole life, your whole world, has shifted again because of my resentencing. I don't want you to live in fear. I want you to find peace, security, and stability that I've taken from you because of my actions. I've put a wedge between you and our grandparents, bridges for everyone in our family. I took away the possibility of memories that could have been. I'm sorry for being a horrible brother to you. I'm sorry for being a monster. I'm sorry I took the lives of our parents. I dropped the emotion battlefield on you. Parents should never have to bear their own children. You had plans for your own graves, but you had to buy plots for mom and dad. You had to go through mom and dad's complicated wounds reopened again and again. You thought you were done raising kids, but now you're raising 3 more in your retirement years. But both of you were more worried about everyone else than yourselves. At the beginning, I wanted to push everyone away because I didn't deserve anyone. But you never gave up on me. You did what many people would never be able to do. You were always there for me. You never judged me. Thank you. Thank you for helping me, man. I am today. Grandma, I know you're no longer with us. And I want you to know you don't have to worry. If I'm given the chance, I'll be there. And I will take care of Oma. I'm sorry. I'm so sorry. My crime affected everyone. Just reading about it in the paper made people wonder, what if? I made the community start locking up their homes, and locking up emotionally. I cannot do what I did, so I wish I could. I realize that all the words I'm speaking today are not enough. I can't go back in time and pick up my family. What I can do is to strive every single day to be the person my family and community deserves. Today, I'm a man committed to continued growth of my journey of transformation for myself and those around me. I can now reflect and recognize how my daily actions impact others. I thank Jehovah for placing people in my life who have helped shape me into the man I am today. I'm grateful for the opportunity to take accountability for my actions and share these words today. To everyone I've harmed, I'm sorry.
And do the people wish to?
Yes, Your Honor. Do you want to be heard by me or Samantha?
Whichever you prefer.
I would probably prefer that Samantha be able to speak first.
All right, Ms. Moore, if you are there, I'm going to send you a request to unmute your device.
I'm here.
Okay.
I'm
sorry. I'm sorry to interrupt, but I'm going to send you a request to start your video. If you prefer not to start your video, you don't have to accept that.
I would much rather not.
Okay. If you would just state your full name and then you can continue with whatever it is you would like to say.
My name is Samantha Moore, previously Samantha Sosby.
All right, you can go ahead.
Okay. I have prepared a statement. After hearing everything, I have made adjustments because I do feel that this court has never fully heard the truth. I will begin now. My name is Samantha Moore, previously Samantha Sosby. I am the sister of Marshall Sosby, who I will refer to as my older brother from here forward to avoid using his name, so I am able to get through this statement. Using my older brother's name in any sense creates significant distress for me, which may affect my ability to remain focused. While providing this crucial, never before heard in this case statement, I have even covered him with a sticky note because I do not want to see him. For this reason, I will refer to him in general terms. I understand that this defense and criminal heavily rely on the victims to be too scared to relive these memories so that they may then paint their own images of what happened. So I am here at the risk of reopening these disturbing memories to relay the full truth. I am submitting this statement after many years of being unable to speak on these matters in a formal setting. Since the horrific tragedy, I have not felt able to testify or provide input in proceedings involving my brother. When I was a minor, I was not permitted to testify in court by my grandparents. And over the years, I have struggled with fear and distress when even receiving correspondences related to the case. I am here now to tell you plainly and without apology how my brother's crimes have destroyed my family's and my life. Since not being involved in this case as much as I could, I am not aware of what the court knows. Do they truly know this evil man's true story? I am curious if they are aware of the real reasons he snapped that night. His cell phone taken from him due to an outrageous bill, cutting his communications with a girlfriend in a different state where they planned to be wed in a Nazi-themed ceremony. I wonder if you were all aware of his dark side and his demons he believed he could summon to hurt others, or of the violence he inflicted upon his siblings throughout our childhood. I truly feel the courts are in the dark on how deep his evil is rooted. I am here today to fill in those missing pieces to this story. In 2008, he brutally stole the life of our parents in front of me and my younger brother, Devin. That moment, like so many others during our childhood, was only one episode in a long history of violence and cruelty. Growing up with him was not merely difficult, it was a constant nightmare. We endured repeated physical beatings, relentless psychological abuse, and sexual abuse when he felt it was deserved. As if those things weren't enough, he would turn our parents against us by destroying or damaging things. For example, dumping every single item of clothing in the middle of our rooms and telling our parents that we did it because we hated them. He often created situations designed to turn the adults against us while protecting his own image. What frightened me the most was how quickly he could change his behavior when authority figures or adults were nearby. Moments after hurting or threatening us, he would instantly smile, act calm, kind, and completely harmless. A perfect angel. I remember him hurting us. And then, the moment he heard an adult approaching, switching demeanor entirely, while silently squeezing or pinching our arms as hard as he could as a warning to not say anything. That constant message that speaking up would lead to retaliation shaped my childhood and is a large part of why I have remained silent and fearful for so many years. We, as children, tried to get help. We told our elders. Throughout my childhood, my older brother used intimidation and threats of violence towards my younger brother, Devin, to influence what he reported to our parents and family. Because of this, my younger brother would deny my accounts and support my older brother's versions of events out of fear. Over time, this led to my parents believing that I was not credible, as my statements were consistently contradicted by both of them. This pattern reinforced a perception within my family that my older brother was reliable and truthful, and that he could not be questioned. As a result, he learned the needed behaviors and actions to become a master manipulator. He easily was able to put on an act with a face to match an angel, Because of my family's failure to see through this, the harm continued and deepened, leading to that horrible night. I begged to be believed. No one protected us in time. The consequences of his actions are with me every single day. After all these years, I have cycled through numerous therapists and a long list of medications trying to heal from what he did, yet to truly find something to help me. I live with complex PTSD, crippling nightmares, panic attacks that strike without warning, dissociation that makes me feel like I am not in my own life, and a persistent derealization that steals my sense of safety and reality. These conditions have wrecked my health, affected my family and relationships, undermined my work and previous schooling, and forced me into a life shaped around fear and survival instead of growth and joy. Forever, our family will suffer because of this man. Family who will never get to feel their love. Our parents will and have already missed major life events. They have missed their grandsons' births, our weddings, graduations, ceremonies. Their baby boy, my youngest brother Tristan, will never know their voices or mannerisms. Life forever changed because of this man. I am angry. I am angry for what he did, angry at the long shadow he cast over my childhood, and angry at a system that has failed to stop him sooner. But beyond anger, I am terrified. The thought of him being released haunts me. I do not want him near me, my family, or anyone else he may encounter in the public. One of the most painful parts of this process has been hearing the narrative simplified in ways that erase what I experienced directly at his hands for years. Part of why I have remained silent for so long was because attempts to speak out about the abuse and fear within my family were minimized or explained away. My own grandmother stands on my brother's side, even after I told her the whole truth as a child. Likely, this is why she did not allow me to testify as a minor, as well as why she and I have not gotten along. Her defense is despicable and a dishonor to the truth, as well as a slight against my mother and her own son who loved her dearly. Even after disclosing what we experienced living with our older brother, the truth was dismissed rather than protected and brought to the court's attention. Her involvement with my older brother was one of many reasons why I left her home when I was only 16. Even after leaving their place of residence, her support was non-existent, pretending I did not exist, as she did with my mother countless times before, and even refused to support my continued education when I was in high school. The silence and disbelief of her actions follow me even now. I know the defense may focus heavily on my father's shortcomings and conflict within our household. So many stretched truths have been told over these years. It sickens me to hear these things about our father. While he was not perfect, he brought so many smiles to our family as well as anyone he encountered in the community. Many people have even come forward to tell us of the lasting positive impact he left on their lives after his passing. To hear him being painted a terrible father or an abuser is sickening and a cheap excuse for my older brother's terrible actions. Yes, my family was not perfect, and there were unhealthy dynamics and discipline that affected all of us. I do not deny that. But I also need the court to understand that my brother's abusive behavior began long before the murders, and cannot simply be explained away as one emotional outburst. As far back as I can remember, I lived in fear of my older brother. The abuse, manipulation, intimidation, and harm I experienced from him were ongoing patterns of behavior that existed independently of any single argument or incident in the household. If anything, he was the favorite because he was never seen or caught doing wrong. Through the scapegoating and intimidation methods he practiced daily. I understand the courts may hear about his good behavior while incarcerated. I cannot say that behavior surprises me. In my experience growing up with him, he was able to present himself one way to authority figures and another way behind closed doors when he had us alone. One of the most terrifying aspects of living with him was that retaliation did not happen publicly. It happened privately when no one else was there to witness it, where he would whip us with belts. He would punch us. He used his little sister's body in any way he felt and screamed as loud as he could in our ears. He always made sure to get even. This is what created an environment of constant fear about speaking up or against him. Because of that, outward compliance alone does not make me feel safe, nor does it reassure me that the underlying danger is gone. I know his tricks. In many ways, his ability to appear controlled and cooperative to others was always part of what made him so difficult to protect ourselves from. He has shown a pattern of manipulation and control his entire life. His ability to charm and deceive is not rehabilitation. It is the same skill he used to harm us and evade accountability. If the court considers any reduction in his sentence or early release, I beg you to put the safety of victims and the community first. Do not be persuaded by polished behavior in custody. I am here to ask the court to recognize the full ongoing damage he has caused. This is not a past chapter that I can close. It is a wound that bleeds into every part of my life. I urge you to weigh that harm heavily in your decision. I am begging the courts to keep this man locked up, not only for my safety, but for my family and the public. I understand the courts may consider his good behavior while incarcerated as evidence of rehabilitation. I reiterate my urge for you to understand one of the most frightening aspects of his behavior was his ability to appear controlled, cooperative, and even kind to others while creating fear privately behind closed doors. The night our parents died, I truly believed I survived because I told him I would not speak against him and would lie to the police about his actions. This moment of fear for my life reflects the level of fear I lived under the extent to which I believed retaliation was possible if I went against him. Even now, as an adult with children of my own, the thought of his eventual release fills me with fear. That fear did not come from one isolated incident. It came from years of experiencing his terror firsthand. Please consider the absolute maximum sentencing possible for this man is an absolute nightmare when left unchecked. Do not allow his polished acts and words to fool you. He was less than 2 months away from being an adult when he killed my parents. He knew what he was doing. Please do not allow him to exploit this hole in the law. Thank you for hearing me today and for considering the real and lasting costs of his action. I am only alive today because I lied to him when he threatened my life that terrifying night. Please don't let this monster fool you with his good deeds and model citizen behavior. He is a true master manipulator who had our entire family fooled.
Thank you, Your Honor. As the court knows, I wrote a resentencing memorandum. I'm not gonna readdress things in there, but there are a couple of things that I wanna say for the record. One is, I believe it's worth noting that Mr. Sosby was originally sentenced on a second-degree murder convictions, one of a life sentence and one of 375 months to 750 months. It is because of the life sentence that we are here today. Again, as was indicated by Ms. Swain, we are here because of People v. Stovall, and this court's bound by that. But this court also has the ability to sentence Mr. Sosby to a lengthy term of years. There has been no parameters put on that term of years, except for obviously this court needs to and must consider youth as a mitigating factor when taking into account the snow factors and determining a proportionate sentence. That is not disputed. This court is in a very unique position, resentencing Mr. Sosby 17 years later. And again, I'm not going to reiterate the legal arguments and specific facts of this case. Mr. Sosby pled in this case, so in terms of a record, we are limited. I would urge the court to take Samantha Moore's statement and understand the complicated dynamics of this case and the selfish acts of Mr. Sosby and the significant detrimental impact it has had on this family, not only of Ms. Moore, but his siblings, his other siblings, Devin and Tristan, who have not provided impact statements, which is their prerogative. I would like to note that OB5 was scored at the maximum of 15 points. That is psychological injury sustained by a member of the victim's family. It absolutely does not adequately account for the psychological injury that Mr. Sosby has caused his siblings and his family. Just like this court can take into account Mr. Sosby's MDOC record, which I do not dispute, that he has taken advantage of the programs available to him and has seemingly on paper benefited from them. But this court should equally be able to take into account what's happened to the victims over the last 17 years. They would not, back in 2009, 2010, when he was originally sentenced, been able to do that in the way that they are able to do that today. There are multiple versions that have been presented today and in the past of what happened, not only on that night, that day, but what has happened in this family prior to that. But there's no doubt, and defendant himself has admitted that he premeditated the murder of his father. While he did plead to second-degree murder, that premeditation is not in dispute. There's we're never going to know why exactly Mr. Sosby chose to murder his mother that night. He has apologized for it. He has expressed remorse. However, it also appears that it's quite likely that he killed his mom so that she didn't turn him in. He attempted to convince Miss Moore to lie for him so that he could get away with it as well. Again, this court is in a unique position. It must consider Mr. Sosby's potential for reformation, but it is also appropriate for this court to consider the impact on the victims, the protection of society, punishment, and deterrence, all while taking into account youth as a mitigating factor. The OV total in this case is 260 points, which is more than twice the maximum 100 points. The guidelines are at 225 to 375 months on the second-degree murder convictions. And we are requesting that this court impose no less than 360 months on the minimum. In addition, I would ask this court to impose a no contact with Ms. Moore. And again, as this court knows, it must resentence on all the offenses. We are asking the court to reinstate the same sentences on the other offenses, but we are requesting 360 months on the minimum.
Sentencing in a case where lives have been lost is as difficult as it gets, and I always say that, but this is a particularly difficult situation given the nature of the crime, the nature of the circumstances, and the nature of the emotional devastation that has resulted from what occurred here. The United States Supreme Court in Miller versus Alabama decided that mandatory life sentences without the possibility of parole for crimes committed before the age of 18 were unconstitutional. They violate the Eighth Amendment's prohibition on cruel and unusual punishment. In doing so, the United States Supreme Court acknowledged that as a result of adolescent brain development, children have diminished culpability compared to adults and a greater capacity for rehabilitation. The Michigan Supreme Court in the 2022 case of People versus Stovall held that life sentences with parole for juvenile offenders violates the Michigan Constitution's prohibition against cruel or unusual punishments. Consistent with Stovall, Michigan Supreme Court entered an order in this case vacating Mr. Sosby's sentence as it included a parolable life sentence. Cases decided by the United States Supreme Court and the Michigan Supreme Court make one thing abundantly clear, and that's that youth matters in sentencing juvenile offenders. Michigan Supreme Court has established 4 basic sentencing considerations. Those are reformation of the offender, protection of society, disciplining the offender, and deterrence of others from committing like offenses. It goes without saying that the offenses here are among the most serious that we face in society. 2 murders, felony firearm, assault with a dangerous weapon, and interfering with a police investigation. I received a lot of information about this case and have had the opportunity to hear the attorneys make their arguments, hear Mr. Sosby make his statement, and hear Ms. Moore make her impact statement. And those things are difficult at this point, having just heard it, to reconcile. Obviously, Mr. Sosby had no prior criminal history before committing these offenses. But he did commit these horrendous offenses that devastated the family. The parents are both gone. Mr. Sosby has been in prison. His siblings were left without the adults in their immediate family and were raised by their grandparents. Emotional wounds caused by these crimes obviously have not fully healed. They likely never will. And as we just heard, are, at least in one case, wounds that are still very raw. Mr. Sosby was 17 years old when he committed these offenses, which include the murder of his parents. His family and home environment, as outlined in documentation that I have, were dysfunctional, and I would even say highly dysfunctional. Most significant characteristic of that environment in the record that's before the court is the physical and mental abuse that was occurring in the home. Started at a very young age, very early in life. And unfortunately, Mr. Sosby's mother was unable to protect him. And for years, he didn't have any viable means of escape due to his youth. Research suggests that juvenile offenders have a greater capacity for rehabilitation. And again, based on the record that is before the court, that appears to be on display with Mr. Sosby. While in the custody of the Michigan Department of Corrections, Mr. Sosby has taken steps to get an education, to address the issues that he faces as a result of his difficult childhood and the crimes that he's committed, and to help others take steps toward rehabilitation themselves. His record while in custody includes only one significant infraction over a long period of time. It's extremely low when measured against the typical rate at which inmates accrue infractions. Based on the report of Richard Stapleton that was attached to defendant's brief, stands in particular contrast to the fact that younger offenders are more likely to have a higher number of infractions while incarcerated. There's been an argument or a statement here today that that behavior is part of manipulation by Mr. Sosby to look good or minimize what's happened here. But I would note that the length of time that this behavior has gone on and the setting in which it has gone on suggests that it is something real and substantive as opposed to the manipulation. And so it is a very difficult job to try to reconcile, again, the crimes that have been committed and the devastation that results from those crimes. On one side of the scale, and on the other side of the scale, Mr. Sosby's really exemplary record while he has been incarcerated. He has done everything that society asks a person to do in that situation. And it would appear at this point, based on all of that, that he is at a low risk to reoffend. It would appear that he has been significantly reformed during his time. and that given the decreased likelihood of his reoffending, that society would be protected by a lower sentence than what was originally imposed. With the understanding that sentencing for juvenile crimes, the focus shifts away from discipline and deterrence and toward rehabilitation and reformation. I don't believe that the discipline of the offender and the deterrence of the offender and others is completely removed, and I do believe it is still consideration, and it must be here based on the nature of the crimes. And so today is an attempt to balance two things that in some ways feel impossible to balance. Ultimately, I come back to what I said at the beginning is clear from the decisions of this U.S. Supreme Court and the Michigan Supreme Court as it relates to juvenile sentencing, and that is that youth matters. And those factors must be considered and are considered here today. With respect to the interfering with police investigation, sent to the court that Mr. Sosby served 57 to 120 months with the Michigan Department of Corrections. With respect to the assault with a dangerous weapon charge, it's the sense of the court that Mr. Sosby served 23 months to 48 months with the Michigan Department of Corrections. With respect to both of the second-degree murder charges, it is the sense of the court that Mr. Sosby served 260 months to 750 months with the Michigan Department of Corrections. And with respect to the felony firearm, it is the sense of the court that Mr. Sosby served 24 Department of Corrections. By law, felony firearm has to be served first, and the other charges are consecutive to the felony firearm charge. Ms. Holly, do you have the credit on? Keep finding it quickly.
From 9/24 to 08, 9/24/08 to 5/14/26 It's 6,441 days. Any of that credit would go toward the felony firearm first.
6,000.
441 days.
So we'll have to do the math on that, but it's 6,441 days total. The first amount is applied toward the 24 months of the felony firearm, and the balance is applied toward the remaining charges, which are concurrent.
I don't know if crime victims' rights fee and state costs stay the same. Crime victims' rights fee since 2010 has gone up to 130. He was ordered 60. I don't know if that would change. State costs are the same.
I will impose the same costs that were assessed at the first sentencing. I believe that's appropriate given timing. Mr. Sosby, the bailiff is going to hand to you 3 copies of the notice of right to appellate review and request for appointment of attorney form. Need to sign the top copy of that form, and in case that you received your copies of those forms, return that to the bailiff. If you want to request an appeal of your sentence and have an attorney appointed for you to do that, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
Did you want to add a no contact?
Thank you. We'll add a no contact provision that Mr. Sosby not have contact with Samantha Moore. The record should reflect that. You do have a copy of the signed appellate rights form from Mr. Sosby and placing that in the file. Is there anything else that needs to be addressed today?
No, Your Honor, thank you. Nothing from defense.
All right, thank you for your time.
Alrighty, friends, it's rare that we go an hour and 20 minutes before I say once again, good morning, everybody. Welcome to TCF Live. Happy Thursday. But we jumped right into the deep end. And, you know, I think sometimes people think I plan this stuff. I don't. I catch stuff live. Sometimes I might have an inkling of what's going on, but normally I don't. And we just kind of see what we see here. And this was jumping right into the deep end of the pool right away. But I have info. Some of this has already been discussed in the chat. Some of it was discussed by the judge, but I want to make sure that we're all up to speed on what we just saw. So this was Marshall Scott Sosby, and he was born in 1990, and he was 17 years old at the time of the crime. The offense date was actually September 23rd, 2008. Michael Sosby, age 40, and Carmen Sosby, age 37, were his parents and also the victims. He shot both parents inside their home during a fight / argument about cell phone usage. He initially reported their deaths as a murder-suicide, so he tried to deflect. In November of 2009, he took a plea. The plea was 2 counts of second-degree murder plus related charges: felonious assault, felony firearm, and interfering with police. So on January 8, 2010, he was sentenced. That was Judge Timothy Picard, who is no longer on that court, as far as I know. He was sentenced to life in prison, but paroleable. He was given 31 to 62 and a half years for the murder of his father. And the life in prison with possibility of parole was for the murder of his mother. 31 to 62 and a half for the murder of his father. Probably less because I think the father was viewed as an abuser there. 2 for the felony firearm, and he would have been eligible for parole at the 33-year mark. Now, along the way, and Judge alluded to this, the Supreme Court made two rulings. In 2012, they took up the case of Miller versus Alabama, and this is the U.S. Supreme Court. And it was decided there that defendants under the 18 at the time of the crime could not be sentenced to life without parole, even though he was technically sentenced to life with parole. But they found that unconstitutional in the Eighth Amendment. In 2016, the Supreme Court took up Montgomery versus Louisiana, which basically made Miller retroactive. And Michigan responded by implementing MCL 769.25, which basically opened the doorway for these youthful juvenile offenders to be resentenced, even if it wasn't life without parole, but a life sentence, because at the time, Michigan had one of the highest populations of juveniles who had been handed life sentences. So ever since then, which was around 2016, after the Montgomery versus Louisiana ruling where the Michigan legislature stepped in, ever since then, they've been kind of going through and cleaning up and resentencing these people. So that is the deal there. Now, with the sentence he just got, it translates to roughly 21 and a half to 62 and a half years. He's served around 17, so he's got a ways to go before he would even be considered for any kind of a release. So that's where things stand with that. So anyways, just to bring you all up to speed, if you've got any more questions or thoughts or anything, let me know in the chat and we'll work through it. Let's do this. Let's go to Lake County, Ohio. We'll say good morning to Judge O'Donnell.
Thank you, Your Honor. We're here today in the state of Ohio versus Taylor Maxwell, case number 25 CR 1518. The defendant is present with counsel Chuck Langmack. We're here today for a sentencing hearing. We were last before you on April 6th for a jury trial. At that time, the defendant was found guilty of 3 counts, the first being illegal conveyance and the second 2 being aggravated possession of drugs, both felonies of the 5th degree. After that hearing, a pre-sentence report and drug and alcohol report were ordered. Those reports have since been completed and the defendant has 51 days of jail time credit. Thank you.
Thank you, Mr. Langmack.
Thank you, Your Honor. On behalf of Mrs. Maxwell, we are asking Your Honor for you to grant community control to her. We understand the seriousness of a 3rd degree felony. It is not to be taken lightly. And frankly, neither are the 2 5th degree felonies of possession. The nature and the actual charges suggest there is a drug issue here. And there is. There is a drug use issue that she has. She needs to take control of it because so far it's taken control of her. It's made her do things that are frankly stupid and unadvised, and she's made bad decisions because of the dependence and the addiction to the drugs. Done things that she wouldn't normally do and does things that most people would not do or even consider. That is unfortunately the problem with drugs. They take you into a place that you don't want to be and you shouldn't be, against your will almost. Certainly nobody's forcing her to use the drugs.
I wouldn't say it's against her will.
You know, it's, as I was starting to say, it's nobody was forcing her to use the drugs, Your Honor. That is her fault, and it's sort of that voluntary intoxication. When you do something purposely and intentionally, the things that follow afterwards, you have to own. Those are also your fault. Even if you're not thinking clearly while you're doing it, it's because of your first action of using the drugs. It's nothing this court hasn't seen a million times before, and unfortunately, we'll see a million times afterwards. It's just one of the issues, one of the many issues we have these days. Ms. Maxwell does want help. She wants to not be here. She wants to not be dependent on drugs. She wants to not use the drugs. She needs the help in order to help her do that, or rather not do the drugs.
She
She's got a
seems
lot of-
rather resistant to help, according to what's in the PSR.
She has been in treatment before. She has gone through the process.
Well, that's not what I'm talking about. I know she's been through a million different things, okay? But one of her first statements she makes is, this is all bullshit.
Agreed. I think,
And she, if she truly wants treatment, okay, she also wants to dictate what that treatment is, because she ain't going to NeoCap. So you tell me she wants help. This tells me she don't want help. This tells me she wants to be left alone, because this is all bullshit. This should have been in Muni court, right?
well,
That's not my observation, that's her observation.
correct. And I think it's, anybody in this situation would certainly have rather had it in Muni court. Maybe, put myself in her shoes, might think that this should be a Muni court.
Okay, but
I think
that's
anybody.
over with, okay? It left Muni court months ago, months and months ago it left Muni court.
That is accurate. That ship has sailed, and there's no going back there, and it's over. And there was a trial, and she was convicted of it, so it's whatever she would have hoped for, or thought should have happened, could have happened, or wanted to happen. It's moot at this point. What's happened has happened. She was found guilty through trial. The issue she now has to face is the consequences for that. Certainly that's why we're here today, and that's what you will determine today. What she is hoping for is some leniency in allowing her to engage in treatment. I think it's not a bad idea for her to get that. I think it's a great idea. Now the question is, will it work?
Well, it's a great idea if she actually does something about it. It's a bad idea if she doesn't do something about it. She's demonstrated, once again, in this report, that she doesn't want to do something about it.
Well, as far as the comment on NeoCap, I certainly say, and I'm sure just about everybody in this room that deals with this, it is not the first time we've heard somebody say, I'm not going to NeoCap. NeoCap does not have the best reputation in the jail.
Well, who
and people
cares?
talk.
Who gives a rat's ass what the reputation of NeoCap is amongst the people that are in the jail because they can't control themselves? Who cares? I don't care.
Oh, I'm not saying that justifies it. I'm just saying you get a lot of people saying, there's a lot of jail talk. Oh, that place is terrible. That place is bad. It's not going to help you. And you can't help but listen to it because where are you going to go?
You don't, that doesn't, and believe it.
True.
I don't know why somebody in your position believes anybody who says anything over here.
And I
Because what percentage of these people are hooked on drugs over here?
I don't know.
Aren't the biggest liars in the world the drug addicts?
Mm-hmm.
So why you believe
And
anybody
politicians.
over there?
Yeah, I agree, Your Honor. I counsel every one of my clients to, you can sit there and they can talk, but I wouldn't listen and I wouldn't give any credence to it. Because that's up there with, I know a guy that killed somebody and only got 3 days in jail. I mean, the stories that are told over there are just that. They're stories and opinions and often way skewed. So I do advise all my clients not to listen to what's been going on. Because these are the people that are in there next to you. And just as you have made bad decisions to end up in jail, they have also made bad decisions. Sometimes worse, sometimes not as bad, but all the same, they're in jail for a reason. And that's not somebody I'm taking advice from. So, Your Honor, even in light of all that, we would still ask for community control. I think it would not be a bad decision to put her on community control and allow her to try to get the help, because if it doesn't work, it will be her own fault, and then the consequences still remain in place. I mean, she has 5 years over her head with these 3 charges.
But that argument exists in every criminal case that exists, okay? But I'm looking
It
at,
does.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 separate instances of treatment since 2017 through now.
That's a significant number, Your Honor. Can't argue against that. And I'm not here to tell you this will be lucky number 13. You know, this one will guarantee everything will be fine. This one will click, and all of a sudden, the sun will shine, the birds will sing, and her life will be smooth from here out. I can guarantee you that. No one can. All I can say is, from my talks with Ms. Maxwell, that's where she wants to go. She's had enough of the clouds and the rain because it's landing her in jail, which is not a place anyone likes to be, Ms. Maxwell included. Certainly, it is the hope of myself, I know her parents who are here, Ms. Maxwell, and frankly, I believe it is your hope, as well as the prosecutors and the probation office, that this is the turning point. I mean, that's all we want for her. No one in this room wants her to fail. No one in this room wants her to not get better, not get a hold of this addiction.
You know, hope is
That I
not,
know, for certain.
hope is not a plan, and hope is not a strategy.
It is not, but hope is needed in order to help with the plan, with the strategy. We're not saying, and I'm not asking
Actually,
for you to let it go.
execution of the plan is what's needed. Not hope that she'll execute, but actually execution.
And, well, there are several facets to it, Your Honor, and then you're 100% correct. That without the execution, you can have all the hope in the world and it won't matter. If you don't do it, just hoping is just that, just hope and nothing. There are many parts to this, and they are all up to Ms. Maxwell. I can't make her better, you can't make her better, no one in this room or in this world can make her better except for Ms. Maxwell. We can all help as much as we can, we can suggest, we can encourage, but ultimately, it all comes down to her. If she gets the help, is earnest about it, does the work, it should work. But if she doesn't, obviously it's not going to. No matter how much we all want it for her, it won't. And that's, unfortunately, that's the case for everybody. Sometimes you can't force somebody to do the right thing. They have to want it bad enough for themselves. And I think she wants it. And we're asking Your Honor to grant her that opportunity to work, to put in the hard work, because it's going to be hard work. Get the job done to fix herself, for the betterment of herself and for the rest of us, because Ms. Maxwell, keeping these problems, keeping the addiction, doesn't help any of us. Now, will it directly affect our lives? Maybe, maybe not. Probably not. But it's definitely going to affect her and her immediate surroundings. So it's in everyone's overall interest that she does get the help, that she utilizes the help, that she takes advantage of it. And when other people are trying to help her, work with them. I feel she's ready for that. That's all we're asking, Your Honor, is a chance for her to improve herself. You know, I know her father would like to say something. I don't know if you want to hear from him before or after.
That's up to you.
So, if you want to say something, sir.
Just state your name for me, please.
Randy Maxwell. We've been through this a long time with Taylor, and very sad, but there's a lot of circumstances. She's back where she is right now, and I want you to give her as much help as you can possibly give her. She needs to straighten her head out. It's breaking me and her mother's heart.
All right, thank you. Ms. Maxwell, what do you want to tell me?
I just want to thank you because you've saved my life a few times already. That just, I need help. I mean, I have a baby. I have a 2-year-old baby that needs me, and I haven't been able to be there for him. And I want to change my life.
What are you going to do for the 2-year-old when you can't take care of yourself?
I have to change myself first
Right.
and get help. But
You can't even think about helping the 2-year-old.
I know
Why did you say this is all bullshit? It should have stayed in uni.
because I was not thinking straight. I was freaking out because I was, just detoxing and I was in jail. And like I said, at the beginning of you revoking my bond, I was mad because
Why were you mad?
I thought I could do it on my own, and I
Okay,
was
well,
not thinking clearly.
Why was your bond revoked?
Because I failed the drug test.
Right.
Yeah,
So why would you think you could do it on your own?
because I was in a psychosis. I wasn't thinking straight, but like I said, I thank you for that now because since then I feel like a whole different person. I mean, I can't even believe the things I was doing.
Listen. The worst possible tact you can take right now is to try to bullshit your way through this.
Okay.
Because what I'm about to discuss with you is all the nonsense you've been engaging in over here.
Okay.
From the time you got arrested in October, and then when you went back in April, you've been playing games with your medication. What medication were you prescribed over here?
I was prescribed the comfort meds that they gave me.
What?
I don't, I really don't even know some of them
Why were you prescribed medication over there?
because I was coming off of drugs, and that's what they gave me.
Okay.
But
So you don't know what they gave you?
they gave me something for sleep, something for anxiety, something for my stomach.
Then why were you passing it on to other people?
I was found not guilty for that.
Okay. I didn't ask you if you were found guilty or not guilty. Why were you passing it on to other people?
I wasn't,
You weren't. What did I tell you before? This is a bad time to try to bullshit me?
okay.
But you can do it if you want. It's up to you. Because you've demonstrated that you do whatever you want, whenever you want to do it.
I gave somebody a Tylenol
Why?
because their tooth was hurting. And I felt bad for the girl.
You don't get along with anybody over here?
I try to get along with everybody.
Because they're all ratting you out for doing it for the same thing.
I know.
Is it all just a coincidence or a conspiracy? What is it?
No.
No? So it's true?
That I was passing my meds out? I passed out a Tylenol.
That's it?
Yes.
Okay. Who's given you the sound advice that NeoCap's a horrible thing?
I didn't
And
think
you
it-
don't want to go?
No, I've been to NeoCap and I thought it was a great program, but they didn't give me my Suboxone.
They didn't give you your drugs?
I don't want to be back on Suboxone. I want to be back on, or try the Vivitrol, or the Sublocade shot.
Well, how would the Sublocade shot help you when it comes to methamphetamine?
Because originally my drug of choice was heroin.
Okay, so you moved on. So you've been, in the past, you've been on methadone and Suboxone, right?
Mhm.
And so you stopped, did you stop using the heroin?
Yeah.
Huh?
Yeah, I did.
Okay.
I was sober for 4 years,
And you started using the meth?
2 years ago, and I haven't been able to get myself off of it.
Okay. So when do you claim to me that you were sober?
When I left Neil Kennedy till when I had my son,
Then why did he have marijuana in his system when he was born?
because I took an edible when I was because I was in labor for 3 days.
Okay. so when was he born? What's his birth date?
April 7th, the day I got here.
April 7th of 24, right?
Yeah.
So from April of 2020 through April of 24, you were sober.
Yeah, you can ask my parents. I had a good
Randy,
job.
is that true, to your knowledge?
From when I.
April of 20 till April of 24.
Yeah, oh, yeah, she was sober for a long time.
Okay.
And then there's a story behind this that it would take me days to tell you about.
All right, so,
Very abusive relationship, you know, it's a very crazy thing.
all right, so,
We witnessed it, so, I mean, it was. Oh, she was doing great until, for a long time.
all right, so you were on probation with me May 30th of 19, well, actually intervention. Intervention was revoked December of 20 because you tested positive for opiate, methamphetamine, and cocaine November 13th, okay? So this April 20 to April 24 doesn't match up to your 4 years, okay?
Okay.
So your intervention was revoked, you were convicted December of 20. And then I let you off of probation July of 22. And so I presume that I let you off because
I was doing the right
you
thing.
met the conditions and you were testing negative when you went to probation.
Mhm.
Okay, so I'll go along with you that from December of 20 through July of 22, so a period of about 19 months you weren't using, okay? And then in July of 25, you must have been using again because you got a theft out of Medina.
Mhm. Yeah, like I said, 2024 is right after my son. I just went off the deep end because it's just a lot of stuff. That it's not
Okay.
anybody's fault besides myself. I understand
You're right
that.
about that. Now, so tell me why, after, let's go to April 7th of 24, why, if you had not been using since December of 20, did you all of a sudden decide in April of 24 that the gummy was a good idea? Knowing what it was, right?
Yeah, because I.
Why? Why would you go back to what you had been doing the previous several years?
Because it was weed and I was in labor for 3 days and I was like trying.
What do you mean it was weed? What does that mean?
The gummy was weed.
Right.
It was from a dispensary, so I knew it was safe.
You know it was safe? You're a drug addict. You knew the drug. Is marijuana a drug?
Yeah.
Okay, so what made you, who had maintained at least some period of sobriety, probably longer than any time in your adulthood,
Yeah.
what made you think that taking an addicted drug when you're a drug addict would be a good idea?
It wasn't a good idea.
And what made you think it wasn't? Because presumably you were thinking with a clear head by then.
'Cause I was in labor for 3 days. Like I said, I was just trying. I didn't know what to do. I was miserable. It was bad. So I don't know. I think my baby dad just gave it to me or offered it to me, and I was like, whatever. And that was that. But it was not a good idea at all because that's how all this got started. And then that's when I
That's right.
really went off the deep end.
So which of these mental giants over here convince you that NeoCap was a bad idea, or was worthless, or whatever they
Oh,
told
I
you?
don't think it's worthless. I think it's a great
So
program.
why were you talking against it then?
Because like I said, I wanted to be back on my, like, Suboxone at the point, and I wasn't thinking straight.
What good does Suboxone do if you're sucking down meth?
It doesn't do any good together. Not at all.
So is Suboxone some sort of magic potion then that's gonna keep you clean of everything?
I mean, it kept me clean for, like you said, December to 2020 till.
Okay. So why did you start taking meth?
Why did I? Because I got my baby ripped basically from his bed. My baby dad was beating the shit out of me. I mean, I could go on, but it's not anyone's fault. Once again, I understand that, but at the end of the day, I was going through it.
So let's get back to the NeoCap thing.
Okay.
Tell me the source of your resistance to NeoCap as you profess this in your pre-sentence report.
Like I said, I wasn't thinking clearly. I probably should not have said that. I definitely shouldn't have said that.
Well, it was a stupid idea to say it.
Yeah.
Okay. But if you thought NeoCap was helpful in the past, why would you say that this time?
Yeah.
Because of who over here?
Everybody. Basically.
Everybody. Nicole Henderson tell you that?
Yeah.
Crystal Smith?
Crystal Smith, I don't know who that is.
Diane Hemphill?
Diane. I don't know who any of those people are.
Martha Cabrera? Sabrina McFarland? I'm trying to figure out who the Council of Geniuses is over there that we should rely on, or you should rely on, to take advice from, for future reference, so I know coming in if they're getting good advice or bad advice. Is it your goal to get out of here today with the least amount of time and restrictions as possible?
No, Your Honor, I need help. I'm a drug addict, I need help.
Everybody seems to realize that except you. For the last 9 years, everybody seems to realize that except you. And one of the first things you said is that you want to go take care of your 2-year-old.
Yeah.
And where is your 2-year-old?
Well, he's with my parents sometimes, he's with his dad, and he's with a foster parents right now.
Okay. Isn't a logical conclusion in this case that the quicker and more thoroughly you get your act together, the better off you will be, your 2-year-old will be, your parents will be? Isn't that logical?
Yeah.
Okay. But you've abandoned logic for most of your adult life, right?
Yeah.
Okay. And who is Daniel Fursick to you?
Nobody, really.
I mean, well, you were with him when this
Yeah,
happened. Who was he to you?
He was somebody that I was running with, really. That's all.
How long did you know Fursick before this?
Probably like 5 years, maybe,
How did you know Fursick?
from jail,
From jail. Where's Fursick now?
prison.
Okay. For roughly the same charges as you, right? Right?
Mm-hmm.
Okay. So what's your plan? What plan do you, because you've been over there for, what, about 6 weeks now?
5 weeks.
Okay. You must have developed a plan other than bitching about NeoCap
Yeah.
and what bullshit this is. You must have since developed a plan as to how you can get your act together and stop running in and out of court. What is it?
I have an appointment at Signature Hall tomorrow to get my Sublocade shot. I will do whatever they recommend me to do or whatever you recommend me to do.
Well, I mean, you're experienced in this stuff. You've been through 12 different treatment places.
Yeah.
Okay. So you're well experienced in this.
Yes.
So presumably you know what works and what doesn't work.
Yeah.
So regardless of what, see, because my recommendations don't mean anything, neither does Signature Health.
Okay.
Okay. They can recommend everything.
Yeah.
And you could do nothing.
Okay.
So what's your plan? What is your plan for success?
And I had a sponsor. I want to get back in. I never really got it. So a problem that I had when I was sober for those few years, I didn't really work the steps. I didn't get into AA. I didn't network myself, basically, I guess you could say. But I want to get into that because I had no sober support. I just tried to forget all this stuff. I tried to stuff it all in the past, and I think that's why I relapsed, really, because I wasn't working on getting better. I was just trying to stuff everything in the past and thinking that just everything was going to go away. So I want to be open and honest with as many people as I can be so I can get as much help as I can.
So it's kind of an immature thought, right?
Okay.
You just, well, okay or not okay. I mean, you wanted to tuck it in the past and forget about it. That
Yeah, it
isn't-
was very
that
immature.
isn't attached to reality.
No, it's not. But this relapse, I mean, I think at the end of the day, I'm going to grow from all of this. So
Did he really just stop that right in the middle? Well, hold on here a minute. Hang tight while I check to see if he restarted it or not. Judge O'Donnell's been doing something different lately. He used to run his streams 9 hours, but now he relaunches every time. Is that the same? Yeah, okay. Hold on. This might, yeah, looks like there's a continuation to this. Sorry, we're doing this on the fly. By the way, because I forgot earlier, because we got caught up in that Sosby case, Tim gifted 5 memberships, and Tim, I failed to acknowledge that, so my apologies, and thank you for gifting those memberships.
The matter set for this case, there might be a...
No, that's not what I wanted. Hold on. This is sloppy live show stuff, I know, but I wasn't expecting him to cut the feed. But it looks like he restarted it, so hang tight while I get it fixed. While working around Ellie.
it was just, I should have just pled out and we could have been, moved on at this point, and I'm sorry for that.
Well, I mean, you don't have to apologize for going to trial. It doesn't matter to me if you go to trial. You're entitled to a trial. So that doesn't enter into it.
Okay.
Whatever I do to you
Yeah.
as a result of this sentence would make no difference if you went to trial or pled guilty. I don't care.
Okay, I didn't know that.
All right. Did somebody tell you over at the jail you were going to be punished more harshly because you went to trial?
Yeah.
Okay. The Council of Geniuses once
Yeah.
again? Okay. Maybe you should listen more to your parents than the Star Wars Council over here. Okay.
I agree.
All right, have a seat. Ms. Bell?
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and the state is certainly disturbed by multiple things. First and foremost, the defendant's attitude. This is bullshit. Should have gotten taken care of in municipal court. That doesn't really indicate a willingness to move past this and get better. We're dwelling that this is all bullshit. The state's also concerned that she has multiple probation violations in her past. She doesn't have a super extensive criminal history, however, multiple probation violations. She's been to treatment 12 times. She had the opportunity to be in treatment 12 times, and here we are yet again. She also has those issues in the jail that are extremely disturbing to the state. If you in jail, it's the time for you to follow the rules and show that you can be a member of the society, and she couldn't even follow the rules while in jail. So based on all, and she also violated her bond by testing positive. So based on all that, the state does not feel that she's a viable option for community control, and that prison is the only choice here. Thank you.
What warrants does she have out, Jamie?
I believe the only one would be possibly in the diamond, because she was supposed to have a change.
It's on the 18th, was my court date. I don't have a warrant.
What's that for?
The same petty theft that I got in that last year.
You have a valid driver's license?
Yes, Your Honor.
Well, that puts you miles ahead of your friends over here, I'll tell you that. All right, I've looked at the pre-sentence report, the drug and alcohol evaluation. Listen to you, listen to your father, listen to counsel. And I have considered all the provisions in 29, 29, 11, 12, and 13. So I'm going to place you on community control for 5 years. You're going to serve 91 days in jail with credit for 51. The last 30 days, you're going to be in the jail treatment program. You're going to complete that and follow all the recommendations. After that, you're going to go to NeoCap. You're going to complete that program and follow those recommendations. When you leave there, you're going to enter into either Oak House or Nevaeh Ridge, complete the program and follow the recommendations. You're to have no drugs or alcohol, and you'll be screened. You're to utilize only one doctor and one dentist and one pharmacy for any prescription medication. You're to take your medication as it's prescribed. You sign releases so probation can get your records. You're going to clear up the existing warrant in Medina. You're going to obtain and maintain full-time employment. Where's the last place you worked?
Daniel Schwartz, the oral surgeon.
You have no contact with Daniel Fursick? And you're going to pay the cost and supervision fees. Any other terms, Ms. Crook?
Only if you wanted to do the sober living or a mental health assessment.
You're going to get a mental health evaluation. Follow on any recommendations. Where were you living before you got arrested here?
At my parents.
Do you understand all the terms?
How long am I gonna do in jail?
I mean, how much longer?
Yeah,
40 days.
40 more days, okay. And then NeoCap, and then, I'm sorry, what was the last thing?
Oak House or Nevaeh Ridge.
Okay. And then how much are the court fines?
Fines? There are no fines.
Oh, I thought you said.
Court costs.
Costs
Oh,
and fees for being supervised on probation.
okay.
Any other questions?
No, I don't think so.
All right, if you do not comply with the terms by this point, you know the drill. The state files a motion to terminate your community control. If I find you violated, then you face potentially 60, or is it 72? 36.
60, Your Honor.
So 2 5s?
Yes.
Okay. Potentially 60 months in prison. You understand that?
Yep.
Now, you have the right to appeal your conviction and your sentence to the 11th District Court of Appeals.
Yeah.
If you have the right to have a lawyer appointed to represent you.
Yeah.
If you can't afford one, one will be appointed at the state's expense. You are entitled to have a transcript of all the hearings. If you can't afford those, they'll be given to you free of charge, and you have the right to have a timely notice of appeal filed on your behalf.
Okay.
Anything else from the state?
Just a forfeiture, Your Honor.
And the items subject to forfeiture are forfeited. Mr. Langmack, anything further?
Nothing else, Your Honor.
All right, now, you can do with this what you want. It's completely up to you. Obviously, I don't have any influence on you. Your parents have had little influence on you. So you figure it out.
I'll figure it out.
It's TCF Live on a Thursday. 2 hours in the books already, and we've seen a whopping 2 hearings. This has been a really weird morning. Doesn't normally roll like that, but thank you all for being here. Barbara, thank you for the $5. Dan, we've got your back. We're one big family here. Thank you. So yeah, just to explain, in the middle of that hearing, he cut the feed, but then relaunched it, as I was able to see. About a week ago, he started putting out his court differently. It used to be he'd turn on the camera at the beginning of the day and it would just run for like 8 or 9 hours while he was in chambers, and then he'd just come out and handle stuff as it came. But now he launches a new stream every time there's a hearing. Makes it easier for us to find out when stuff is going on, but then we can have little glitches like that where if he hits the wrong button and stops it, it makes a mess. But luckily, he apparently realized it and turned it right back on, so we were able to continue. So anywho, with an hour left, we should probably try to do more than just one more hearing. So with that goal in mind, let's go to Michigan and Judge Simpson, where I want you to pay attention to the gentleman named Daniel, who appears to be zooming in from a tent this morning, which I don't think I've ever seen before.
Your Honor, we too do not believe there is a conflict, but would waive any conflict if there is one.
The court, for its part, also just believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people of the state of Michigan versus Stelianne, Cott.
Stelianne, Cott.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of Mr. Cott. Mr. Cotton, please state your name for the record.
Stelianne, Cott.
All right, I have before me a plea form that indicates that he's going to be pleading guilty to the charge of use of a controlled substance, that being cocaine, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That is correct, Judge.
Mr. Cotton, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, state your name again, please, sir.
Stelianne, Cott.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance or use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. And I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You had someone sign rights form on your behalf?
Yes, sir.
Do you have any questions regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights?
Yes, sir.
Understand you're giving up your right to appeal of rights?
Yes, sir.
Are you on probation or parole? You are not, correct?
I'm doing time in Wayne County.
Gotcha. Has anybody promised you anything other than what's been stated here today to get you to plead guilty? Anybody threaten you or force you?
No, sir, Judge Simpson.
All right. You're doing this voluntarily and of your own free will?
Yes, sir.
All right. And also because you believe that you're guilty?
Yes, sir.
All right. I'm done with those questions now.
You know I'm not gonna play with you.
Yes. That doesn't work out for people when they do, right?
Yeah, I ain't gonna never play with you.
All right. Sir, on the date of August 25th, 2025, at the location of West Michigan Avenue near Ellsworth in Ypsilanti Township, Washtenaw County, state of Michigan, did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was cocaine?
Yes, sir.
All right. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, misconduct as defined under the Michigan court rules, that the court would no longer be bound by any sentence evaluation and you could not withdraw your plea. You understand that?
Yes, sir.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
They are.
It's all on the record, Judge.
All right. And have I complied with the court?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
25th at 10 a.m.
June 25th, 2026, 10 a.m. before Judge Washington.
Thank you, Judge.
Sir.
Bond will continue. All right. Good luck to you, Mr. Cott.
Yeah, thank you, sir.
Court calls case of the people versus Anthony Holston.
That's a miscarry I can run.
Oh, boy.
Ready, Judge. Torshell Feaster, Assistant Public Defender, on behalf of the defendant.
Hi, where's Princess? Oh, here she comes. Sorry, I'm just checking.
Morning,
In
Your
our-
Honor.
Welcome.
Thank you, Judge. It's good to be here. Assistant Public Defender, Tanazi Carey-Action-Ruley, on behalf of, I believe this is Anthony Holston.
Mr. Holston, can you state your name?
Anthony Holston.
Judge, we're asking for an adjournment. I think we've reached a resolution with the people. We just need to put the paperwork together and finalize it.
Need the paperwork together then?
Yes, Judge.
We're on the 7th. 28th. Because we've got to do a video, right? So I'll adjourn it to May 28th, 2026, 9 a.m. And hopefully at that time, Mr. Holston will be able to take care of your matter. Okay, sir?
Thank you, sir.
Thank you. Bond continues.
Thank you.
That's court calls case People versus Sarah McCormick.
Turn this over to the people here.
Sir?
Oh, Mr. Snow.
You want to state his counsel, state your appearance. Prompted him. Or still have nothing. All right, Ms. McCormick, we'll call your case back up. We're just trying to get your counsel to finally answer. All right?
Okay.
Thank you. Court calls case People versus Jasmine Morris.
Good morning, Your Honor. Assistant Public Defender Davi Lebo for Ms. Morris.
Ms. Morris?
Your Honor, Ms. Morris is presently at the Walter Reuther Hospital. I did speak with them yesterday.
She's present.
Morris, okay, Ms. Morris, can you state your name, please? Okay, that's Ms. Morris. Got it. Okay. I have a report indicating that she's incompetent to stand trial but restorable.
Yes, Your Honor. And I did speak to the Walter Reuther Hospital yesterday. They've indicated that they are still in progress.
Ready to go home.
All right, hold on.
I'm doing better.
Okay. I'm sure you'll get there. All right, is there any other additional evidence from either side?
No, Your Honor.
Would ask that the court accept that report be stipulated to its finding and ask the court make a finding of incompetent but restorable at this time.
No objection, Your Honor. That is our request.
On a review of that report, I would find that the defendant is at this time incompetent to stand trial, but the treatment is restorable. Court will sign an order to that effect. I will set a review date for.
13.
Set a review date, August 13th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you. Court calls case People versus Anthony Mullins.
Morning, Your Honor. Honorable Court, David Burge on behalf of Anthony Mullins, who's appearing via Zoom from the Michigan Department of Corrections.
Mr. Mullins, can you state your name, please?
Anthony Mullins.
Thank you. I have before me a plea form that indicates that he'll be pleading to an added count 2 of use of methamphetamine, then 1 year offense. Upon a successful plea to that, count 1 would be dismissed. They're agreeing to immediate sentencing.
If the court would do that, Your Honor, I think Mr. Mullins is currently in MDOC and this is what's holding him up.
That's accurate, Your Honor. All right. Mr. Mullins, FYI, we're entering the plea to the use today, sir.
And that's why I did not see Judge waiver part, Your Honor, on the plea form, since that's formal sentence.
Okay, but I got it. Yes. All right.
I think my client's ready to proceed.
All right. Mr. Mullins, can you raise your right hand, please, sir? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God.
Yes, sir.
State your name again, please.
Anthony Mullins.
All right, you can put your hand. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You had someone execute an advice of rights on your behalf?
Yeah.
Do you have any question regarding any of those rights?
No, sir.
You understand that you're waiving all of those rights?
Yes, sir.
Understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, not the time.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Correct.
And also because you believe that you are indeed guilty?
Absolutely.
Okay. November 25th, 2024, at the location of 1701 East Michigan Avenue, Ypsilanti Township, Washtenaw County, State of Michigan. Did you have methamphetamine in your possession?
Yes, I did.
And you used it?
Yes, sir. I was in the act.
Okay. And you knew what you were using was methamphetamine?
Yeah, for sure.
Oh, thank you. Counsel, you're not aware of any other promises, threats, or other inducements which have led to this place?
No, Your Honor.
And have I complied with the court?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you or your attorney want to say before I do impose sentencing?
Your Honor, I would just indicate that he's been in custody for over a year, and also he's been trying to get himself back together. He's completed a rehab through the MDOC as well as attending regular NA meetings, Your Honor. So.
Fines and costs of the state minimums of $125, although there are 365 days incarceration, credit for 365 days, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Good luck.
Thank you,
I'm
sir.
here on the McCormick case.
Lord.
So you just said, really?
Well, yeah.
Like Zoom etiquette?
None of us are here, Judge Brown.
Court calls the case, People versus Sarah McCormick. Recall.
Good morning, Your Honor. Andrew Cito, P87447 on behalf of defendant Sarah McCormick.
Is we have her on?
I'm trying to force it. She is.
All right, Ms. McCormick, can you state your name, please? Oh. I don't have her.
She's unmuted.
I know she's unmuted, but I can't.
Sarah Lynn McCormick.
Thank you. All right, what are we doing on this case?
Judge, this is the first pretrial hearing, and we are still negotiating in good faith regarding a plea deal and also working on more discovery. So we would just ask for a short-term adjournment.
Without objection, probable cause conference will be adjourned May 28th, 2026, 9 a.m. Bond continued. Thank you, Mr. McCormick. Court calls the
Thank
case,
you.
People versus Deshaun Jones.
Your Honor, Raymond Cook for the people.
Edward Rivers for Deshaun Jones. He's approaching.
Your name?
Todd Jones.
Thank you.
Your Honor, I'm asking for an adjournment today. I'm asking for an adjournment.
28th work for you or you need?
Based on some of the mitigation, I'd ask for a little further. The 20
mitigation in or?
We're working together on the mitigation.
On the mitigation. June 11th. 2026, 9 a.m. Bond continues. Court calls case People versus Tanisha Moore.
Your Honor, Raymond Cook for the people.
Defender Secretary, I confirm to Your Honor, on behalf of Ms. Tanisha Moore, who is coaching.
Good morning, Your Honor. Mark Page on behalf of Mr. Moore and file 920. Staying in for attorney of record, Mr. William Amadeo.
Your name?
Tanisha Moore.
Thank you.
Your Honor, in my case, we would be asking for 1 week adjournment. I believe there's a global offer in the works, Your Honor, in this matter. And
There's
that's,
what? A global offer.
yeah, global offer.
That is my understanding too, Your Honor. I spoke with Mr. Cook, and he's gonna forward me the offer that was extended to Mr. Amadeo, and it does involve my case as well as some other misdemeanor matters.
So you'll have everything ready in a week?
That's my understanding for Mr. Amadeo.
I know, but Cook, do you believe that to be the case? Mr. Amadeo say anything to him? No.
Has been extended. I believe that it's likely to be accepted, so we just need to have that final conversation, draft up the plea.
Got it. Yes, okay, I'll adjourn it 1 week out. So I'll adjourn it to the 15th. No, I'm sorry,
I believe that'd be
21st,
21st. Thank you, Your Honor.
21st, 2026 night.
Thank you.
Bond continued. Thank you.
Thank you.
Court calls case People versus Quentin McKenna.
Good morning, Your Honor. Marcia Cratchit on behalf of the attorney of record, Mr. William Amadeo.
Where is he?
I was up.
State your name.
Quentin McKenna.
Is he waiving?
Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination? That was a question.
Mr. McKenna?
I'm sorry, you cut out.
Okay, are you waiving your right to a preliminary examination?
Yes, sir.
All right. Do you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand that by waiving that proceeding, you'll not have that hearing of the circuit court for further resolution?
Sir.
Do you understand that, Mr. McKenna?
Yes, sir.
All right. People also waive their right?
Yes.
Preliminary examination having been waived, defendants bound over to circuit court on the single count.
As to the arraignment, Your Honor, we waive the formal reading, acknowledge receipt of the information, and ask the court to allow my client to stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 8th at 1:30 with Judge Conlon.
Conlon,
Yes.
July 8th, 2026, 1:30, Judge Conlon.
Thank you, Your Honor.
Bond continued. Thank you.
Information, right?
Yes, momentarily. Court calls.
All right, friends, I will keep an eye out for Tent Guy and see if he gets called here at some point. But in the meantime, let's head down to Texas and check in with Judge Stevens.
Okay, this is cause number 25 CR430. You're Mr. Burge.
Yes, sir.
Here, Ms. Holmes, your attorney and the state's attorney. I already have an order amending probation conditions ready to fill out. Let me look at this real quick. Can you summarize what we're
Yes, Your Honor.
asking?
Two issues we were requesting. If Mr. Burge, there's a no contact order right now under the probation terms. If he could have contact with the complainant, Erica Burge, because they do have children together, and the children would like Mr. Burge to be in contact and participate. And so for that limited purpose, we were asking that the no contact be amended so that he could be involved with the children.
Oh, but detail, it's all in the details. What does that mean?
So there was originally a protective order. That protective order has been terminated.
Okay.
So the children have activities that their daughter actually has a graduation next week, in which they would like Mr. Burge to attend. The original orders was not allowing him to do so. So we just wanted to make sure we took care of that. And family courts, that order has been terminated, but we wanted to make sure he's not in violation of probation conditions as well. So we were asking that that condition be amended to have some type of contact so that he's not in violation, because obviously at graduation, he'll be in, if granted, he would be in the presence of Ms. Burge. The events the children may have.
The judge, the wording is important here. There is a current order in family court that grants him restricted access to the children that is supervised by her parents. We certainly are in agreement to him having contact under those conditions. We are not in agreement to co-parenting because that would be against what the family court ordered. If in his contact that is supervised, we certainly don't have any objections to them having contact with the complainant at that time, but not at any other time. That's what that's what I've talked to the complainant. That's what we can be in agreement to as far as modifying the conditions.
Nothing, that's fine. We just needed the period so that he's not in violation of probation. Because it says no contact period, so.
And it is true, Judge. There's a young lady that's not his biological child that's graduating that she would like for him to attend the high school graduation. He's been the father figure for her for years. So we want to facilitate that.
Everybody is bending over backwards to deal with your mistakes. You understand?
Yes, sir.
And I'm talking about your mistakes in plural form. This isn't, we're not here for the first family assault. Or no, this is a subsequent one. And you just can't just get up one morning and it's all finished, done, behind us, and everything is fine. Because a third one is shame on me. Somebody would say, who? What irresponsible judge was monitoring this and responsible for this?
Yeah, you're building.
We all grew up in households. We're in households, almost all of us. Never, and I'm a reasonable, normal person, never could I even fathom this happening when I was growing up. It just went that way. My parents respected each other, which is what should be. And I would never think of wanting my family. You're supposed to be third. Creator is first. Others, especially family, are second. You come in third. Selflessness versus selfishness. Self-centeredness versus selflessness. But shame on you for being in this a second time. I mean, I don't know what you failed to learn in the first event, but this is off the chart. In fact, I've done this for a long time, and I've never had one like this where we had to deal with a second similar family assault event, which makes me, when there's unusual, unique situations, it gets everybody's attention because there's an abnormalcy about all of this. I see a motion that was filed to amend the probation and is requesting.
There was a second request as well by us.
All I have is a May 5th one.
There's two parts to her request. That's fine.
The other one is in regards to the bid classes that Mr. Burge has ordered.
Oh, yeah. Well, it's all here in this motion, right?
Yes.
Yes.
Okay. Yes. Children.
I just want to know.
Would also like for him to be involved in their lives in a responsible way, is I'm sure what they infer.
Yes.
He's requesting to be allowed to have contact in order to co-parent and attend. And his work schedule doesn't give him the opportunity to attend, which is why he's at work. He's requesting the court allow him to attend virtually so that he may complete this requirement for probation. How does this virtual work? Because we've already caught people virtually doing nothing when it's their virtual. they'll turn it on and then they're gone. Then they show back up after it's all over with. And I mean, we've caught people just walking away, and it's a joke.
Yes, Your Honor.
Monitoring this for completion is important. How do we know he's sitting in front of the computer, or I guess the PC, and doing?
Judge, that's why the state objects to that amendment.
Yeah, there's no, unless there can be an independent witness watching him. I don't trust him. He's here for the second time for family assault. I don't trust him. Didn't learn it the first time.
He has since this motion was filed, he since re-enrolled in the program. We've got a letter that was tendered to the probation department yesterday that indicates that, Judge.
Mr. Champ, you carry a lot of weight with me. What do you say about all this?
I say if he attend the program weekly as scheduled.
In person?
Yes, sir, in person, he would gain the benefits of it.
Well, that goes without saying, but what do you mean? So he understands what we're talking about.
We've had countless conversations about this.
He will, I think what you're saying, he will be rewarded.
Yes, sir, he will.
I agree. You haven't earned my trust. So no on the virtual.
Yeah, and is it okay if I contact so we can see if there's possible other times that family services may have to allow him? Because I don't want it to affect that he gets hired and then we're here because they're saying he's not working.
Yeah, I'll give you some time to do that. I think it's in his best interest and the best interest of the family. I don't know where the family is headed as a family unit. Because I just didn't grow up this way. And I don't act this way. I mean, and it's sort of later. Family is everything.
The parties have been divorced, Judge, since
my parents divorced.
I'm just making sure, Judge.
But what I'm saying is, I know where you're coming from.
Yes, sir.
But they still respected each other and had there wasn't any violence or threatened violence. And it was difficult for everybody. But we all, I have 4 siblings, and some of them took it better than others. But it adversely affects the unit. There's something special about a family unit.
Agreed.
Just the way nature and our creator, I think, meant it. And sometimes things don't work out. But that means everyone has to work harder to ensure that all people are respected, and most importantly, the children are not adversely affected any more than is normal under those circumstances. And generally, families, unless they're in violent odds with each other, work together, despite the fact they may be separate legally. That's what I hope. Something special about a family, even when marriage doesn't work. There's so this motion is asking for something that we're not going to I'm not going to allow the virtual classes. He's got to work something else out. You're allowed to contact in order to co-parent. Okay, what about that? Subpart A.
That was what I advised you, Judge, that it's that we agree to contact that is incidental with Miss Burge as it's defined underneath the current family law court order that provides him restricted access to the children that's supervised by.
We need an order doing that, stating that. So could you compare that or somebody could?
I just want to approve the judge.
Y'all's motion in order, y'all could prepare an order in that regard, granting subpart A. And under the circumstances that the state is requesting, I agree, so they can get the family back in the right direction. And then I'd like every 6 months to have a review on how the family's doing. Maybe forward. But yes, sure. I mean, and I don't want to hear it. I don't want to float anything about anything except the utmost respect and honor and politeness to your ex-spouse, the mother of your children, who is the mother of your children. Because you're always going to have to deal with those children together the rest of your lives. No matter what direction you head in, you still have a common, important. How many children? Three gifts from our Creator.
I'm going to talk to the.
How are you gonna handle those gifts that your Creator has given to you? Irresponsibly or responsibly? And with understanding and care. And to the mother of the children. I hope it's in the right direction. Let's fix this, get an order. I'll sign it under the terms that we discussed, and then we'll review it in 6 months. How we're doing on everything. Okay, so best wishes to your goal.
Have a good day.
Derek? Yes.
Alrighty, friends, let's move along. Let's go up to Huron County, Michigan. We will check in with Judge Prill.
H. Ms. Montgomery appears via the Zoom application. She's currently lodged in the Huron County Jail. She's here on a request and warrant for probation violation. On behalf of Ms. Montgomery is Attorney Tammy W. Salins, who is in the courtroom, and the people are represented by Prosecuting Attorney Timothy J. Kowski. The defendant is before the court based upon a request and warrant for probation violation dated May 11, 2026. It contains 4 counts, 2 of which are alleged technical violations, and counts 3 and 4 are alleged non-technical violations. Ms. Salins, do you wish to have the request and warrant for probation violation read into the record? Do you waive the reading?
We waive the reading, Your Honor.
All right. And you've gone over this information with your client?
I have, Your Honor.
All right. And you've advised her of her rights as well?
I have, and she did sign her advice of rights with respect to probation violation.
And that is noted. The court has received that document. As to all counts in this matter, how does your client take this?
She stands mute, Your Honor.
Not guilty plea will be entered on behalf of Ms. Montgomery, and we will schedule this for a probation violation hearing momentarily. Before we set the date, let's see. The original attorney here is Ms. Siv. We'll notify Ms. Siv. How quickly can we have a hearing, counsel?
In a week. Week to 10 days.
Does it sound good to you? Okay. And are you requesting the bond?
Your Honor, we're requesting a cash bond or a very, very high bond due to the allegation of the behavior of Ms. Montgomery of what happened to the 15 years ago.
We're asking for a $500,000 bond. I do have some photographs I wish to show to the court of the alleged victim. This just happened this past weekend. And that's why we're asking for such a high bond.
Have you provided those to the Salins?
Salin's seen them. I don't know if we've actually given her a copy of them.
Or just at least a letter view, I should say. I apologize.
I did review the photo. I reviewed one photo prior to this probation violation hearing commencement.
All right. Any objections to the court reviewing it for purposes of the document?
If I may take a moment to review if there's more than one photo. I have reviewed the photos, Your Honor.
Your position on the court reviewing them.
I have no objection.
Mr. Rakowski, may approach. You can stay right there. I'll just review them very. Ms. Salins, your comment relative to bond.
My client would like the court to know that she has abstained from alcohol for approximately 2 years. This is the first time that she has relapsed. She has indicated to me that she has 6 children. 5 of them are in foster care. She is working closely with the foster care worker for regarding visitation and treatment. She has agreed, they had a TDM meeting this week, and she has agreed to recovery meetings every day. She would also like to go back to chance to change so that she can test either randomly, but she's also willing to test daily. She just started a job at Taco Bell, Your Honor, and she has been there approximately 2 weeks. She has worked from 30 to 40 hours a week. She is asking the court to set bond in the amount of $5,000, 10%. Her children are her life. She is absolutely committed to working with the Department of Health and Human Services regarding visitation and treatment and complying with any services that they are requesting. She also advised me that she belongs to the Lighthouse Assembly of God in Harbor Beach, where she attends there. And so she would ask the court to set bond the amount of $5,000, 10%.
Very well, thank you. The courts had the opportunity to hear the respective arguments of counsel, hear the recommendations for the probation department. Courts also had the opportunity to review the photos of an alleged incident, which are there charges brought, Mr. Rutkowski, in that matter?
There will be, Your Honor. I'm looking for a warrant request. Once I get that, we will act upon it.
All right. And is this an alleged domestic relationship, or at least?
No, not that I'm aware of this one.
Okay. All right.
Would the court like me to remind you of what had happened earlier this year or no?
I recall that.
Okay.
I do recall that. Based upon all of that, it's going to be the position of the court relative to bond in this matter. Bond is going to be set at $500,000 cash surety. Conditions of bond include conditions A through E, GPS tracker, alcohol sensing tracking device, and must be pretrial services beforehand. Also, no contact provision regarding Christina Bresky, Christina Bresky, either directly or indirectly. And that will be the bond. That'll be all off the record.
Sorry, what was the one?
$500,000 cash surety.
Good luck with that one. Alrighty, friends, TCF Live. 20 or so minutes left to go. Let's go to Louisiana. We'll check in with the board, see what's going on.
Middleton, Mr. Middleton, state your name and DLC number for the record.
Jermaine Middleton, 439-330.
Okay. Mr. Middleton, I'm gonna read some stuff into the record. Tell me if you think anything is not right, okay? Looks like you have a parole date of 8/21. You have a good time date of 3/23/2034 and a full term date of 9/15/2039. You are a first class offender. Does that sound correct?
Yes, sir.
Okay, I see we have some new people in the room. Warden, you want to introduce yourself?
I'm Deputy Warden Benjamin Master.
Okay, and sir?
Chief Security Warden Keon James.
Okay, thank y'all for having us today. And I see you also have there Miss Natalie Wilson, subject's mother, and Miss Sharon Kennedy, his sister. I will get to y'all at the proper time to let y'all speak on his behalf. All right, this case has been assigned to Mr. Byroff, so I'm gonna turn it over to him.
All right, just to start out with first question. What did you do to get yourself in trouble here? And why do you think now's the time to be released on parole? Why should we do that?
Well, sir, to be honest with you, when I was younger, I done something terrible. And it affected the lives of people. And I feel really bad about it. And it was a shooting I was involved in, and I hurt people. And I'm deeply sorry about it. And my heart goes out to my victims. One of them was confined to a wheelchair, and I expressed the most sorrow for her, and she was a teenager. Also, the mother who named it, Darlene Goldsby. The daughter name was Athena Goldsby, and it was a Goldsby family. And I just want to apologize for that. And I'm deeply sorry. It happened years ago, and because of that, I've been incarcerated for many years. Over the time period, I've been in trouble. I've been out of trouble. I've been in and out of trouble. But since I made it to this institution, I've grown and I've got myself together. And I think I've rehabilitated myself to where I'm ready to go back into society. It's always gonna be a constant fight. Everything that happened in my life is gonna always be a constant fight. But again, I wanna reiterate on the fact that I wanna show the, utmost, sorrow to my victims. Because I know I changed their lives that night. That night in question, I changed their lives forever. And there ain't nothing I can do to change that. And I live with that mistake. And I'm gonna live with that mistake the rest of my life. But I don't want it to define me. And I don't want it to be the end of the chapter of my life. I want my life to be a success story. I wanna help people. I wanna preserve life. I don't wanna take life. I've grown. I was young then, which is no excuse. But I was young then and I made a mistake that caused me most of my life in prison. And I want to change. I want to make it right. I want to work with youth. I want to help younger kids, so they don't make the same mistake that I made when I was much younger. I just want to get out and be able to, be a productive citizen. And I'm hoping y'all give me this chance, giving me this opportunity to come in front of y'all right now and be able to say what I'm saying now and have a chance to be back in society is a lot. And I want to thank you gentlemen for that. But the sorrow, no words I can say that can explain the sorrow I feel for my victims.
Okay.
Anything I say could, I could talk for hours about it, but.
Right. So why don't you tell us now, why do you think we should let you out today? What have you done in prison?
Well, I got my GED in prison. I graduated a trade in prison, building technology. I learned a lot in prison. I grew in prison. I've been in self-help classes. I've been in AA, NA. I'm in victims impact right now, dealing with the fact of how to deal with, my victims and how to deal with the situation. Because coming up young, I never knew how to show remorse. But since I got older, I put my people in a situation where I put my victims in, and I think, how would I feel if something was to happen to my loved one? So again, I feel like I've grown, and I'm not, young and adolescent no more. I'm more mature, and I know I want to go in my life. I want to be out. I want to be a productive citizen. I want to grow more. I just want to be a productive citizen, and I want to be. My mom, she's kind of sick, and I want to be out there for her, and I would never do nothing that would cause her harm or cause anything to happen to her. I can assure you that I want to go the right way. I want to walk the right path. I am, as I've been here, as I've been at this facility here. I've done what I need to do to try to get myself back on track to get back in society. And I don't intend on stopping. I intend on keep going in the right direction.
How long have you been at that facility?
I've been here 3 years, and counting 3 years and some months now.
Okay. Yeah. All right.
So I'm looking at the records that I got about the classes that you took. And the only major class I see documented is nurturing parent on 5/8/24, that you completed that one. Any classes involving victim awareness, victim letter writing, any?
I am currently in victims impact right now. I'm currently in victims impact right now. I've been in class almost 4 weeks. This will be my 4th week year. And I'm learning a lot from victims impact. I couldn't get in until I got an active date for parole because of how much time I have. I've been asked for it, but they just not putting me in it. I'm just not getting in it. You know, I plan on finishing it, but I've been in Boys to Men also.
What about your 100-hour pre-release? I see you started that on March 6th of 26 and it's not completed. Has that been completed yet?
Yes, sir. I completed tomorrow. Tomorrow will be my last day of pre-release. My last day. Tomorrow. Graduate tomorrow.
All right. I see you had a prior parole hearing on December in 2021, and they were opposed because of opposition from law enforcement, disciplinary problems and conduct, lost 610 days of good time, and your high risk score. And I'm looking back since then, and I was like, tell me about the details of your write-ups that you had since then. Since then, on 2/17/23, you had a write-up, and that was right after. And then you had several more write-ups during that time. Tell me about the write-ups that you had since you went to your last revocation hearing, parole hearing.
Well, again, I have no excuses for the write-ups that I caught after the hearing. I can explain. I got to tour the counselors. I really spiraled down a rabbit hole. I'm saying after I got denied parole, I started, getting into a lot of things. I went to another camp, and I'm deeply sorry about it. I'm embarrassed about a lot of things. But I had to get a hold of myself. I had to do some soul search. I felt like I let everybody down when I got denied the first time. And it was hard on me for a minute, but there's no excuse for it. I want to take accountability for everything. I'm not ducking the fact that, I know I did some things that I shouldn't have. But I think I've got to hold to myself now, and I think I'm ready to go forward.
You didn't tell me, you didn't answer my question. What did you do? I see you have write-ups. I see it's called a 21E. I see it's called an aggravated sex offense. What happened?
I was on after I left the facility I was at, when I went to Hunts, I dabbled into drugs and all kind of stuff. And I was doing stuff that I don't even remember doing. But at one particular time, I got into it with a counselor, a mentor, and it didn't get physical. But I got rolled up for that. And I got rolled up another time. I went to the blocks for something else. I had to really get a hold of myself. I was spiraling back down to the old me. And I had to get a hold of myself. That's what I did. I'm embarrassed by it, but it happened. And I got to take accountability for it. And that's all I can do.
Yeah. My concern is you got denied in the last hearing because of write-ups, and now you're here again and you got more write-ups.
My last hearing, the paper I got, I was denied because of victims opposition, and only victims opposition. I had no write-ups for 4 years. My last hearing, I got solely denied for victims opposition and law enforcement. Disciplinary wasn't a problem.
Well, I believe you got the information wrong, or I got the information wrong.
No, it's written on the sheet.
In the file, it says general disciplinary conduct was the reason for denial in 2021. And they note that you lost 610 days of good time because of it.
I lost 600 days, a good time early in my career of doing time, like in 2001, 3, 4. I hadn't had a write-up when I went up for parole in 4 years, when I went up for parole the last time.
And now it's 3 years, right?
That's 3 years. Yes, sir.
That's not an improvement.
You know, and what's very concerning, you said you spiraled after getting denied. What's gonna happen on the streets if something goes wrong? What you gonna do then?
Something on the street goes wrong, I'm gonna go to self-help class. I'm not gonna stop here. I wanna go to self-help class on the street. I wanna go to 12-step classes. I wanna get mentors. I'm surround myself with positive people. I got positive people in my life now. I got support. My sister supports me, my family supports me. And I'm not gonna be in those type of areas. I'm not even gonna be living in Louisiana no more. It's gonna be a whole total different change of scenery for me. And I don't have that type of mind frame anymore, so.
Where you gonna live?
In Houston, Texas, sir.
Did you interstate compact yet?
Yes, sir.
So you already been accepted to Houston?
It's getting processed as we speak. It's getting in process.
Okay.
I don't have any more questions.
Okay, let's hear from the warden. Warden, what you have to say about him? Tell me about his disciplinary. It don't look good at all over here.
Yes, sir. So in his 25 years of incarceration, he has about 45 disciplinary reports. He has been disciplinary free in the last 3 years since he's been here. The last 10 years, it looks like he's gotten, since 2016, he's gotten 4 separate incidents, which occurred after his last parole denial. He currently is in AANA participation. He completed Boys to Men, completed Nurturing Parenting. He is now in the Victims Impact program. He is considered a Strive inmate here. He's a member of our Strive program, an inmate barber. So throughout his incarceration, he does have a lot of disciplinary reports, but it is a positive that he has gone the last 3 years without any disciplinary infractions while at this institution.
Thank you, Warden. We appreciate that. Okay, let's hear from the people that are here to speak. Let's hear from Mr. Kerry Myers first.
Yes, good morning. Kerry Myers with the Louisiana Parole Project. We're here for Jermaine Middleton. Should the board grant his parole today, Parole Project will provide him transitional housing and transitional programming after 25, 26 years of incarceration. Obviously, Mr. Middleton would be walking into a world that's different from the one he left. He would be evaluated immediately by our social work staff for any recommendations for continued support systems. We know that, he has done some work while he's in prison. He's earned his GED. He's completed RDAP program, the residential drug program while in prison. He's NCCER safety certified. He's completed tier walker training. He is a first offender. He is planning on going to Texas. His interstate compact is in process. He would come to Parole Project once he completes Parole Project and that interstate compact is approved. He would then go to Texas. Parole Project would continue to provide him with contact and support on a long distance basis. But while he is with us, he will have programming. He will, again, as I said earlier, he'll have his evaluation with our social work staff. He'll have programming in technology. He'll have programming in financial management. He'll have programming in goal setting. He'll have peer mentorship programs while he is with us. We are here to help his transition to this board granting parole today.
Okay, thank you, Mr. Myers. Appreciate you. Okay, Miss Natalie Wilson, subject's mother, what you have to say about your son?
Well, I've been missing my son so much and seem like, I just can't go on. I've been in bad health and I really don't know how long I'm gonna be with him. I do know this, my son is totally different from when he was first, incarcerated. And from his visits and stuff, I know the change and the Bible studies and it's just a whole different change from
Yes,
when,
ma'am.
as when he was. But I know my son he's telling the truth. I know that.
All right, is he gonna be living with you in Houston?
He's gonna be living with his sister because I'm a low income. And I
Okay.
have money. Yes, I'm on house.
I just want to make sure who he was gonna be with.
Yeah.
Okay, let's hear from your sister, Miss Kennedy.
Good morning. I just wanted to say that, I'm a public servant myself and I'm a good judge of character. And, for me to stick my neck out for him, that says a lot. He has, rehabilitated himself. I do feel bad about the situation myself, but it's been a long time. We want him home. He knows what the expectation is from me. I've always had this expectation for him, which is why, the situation is what it is, but we're ready to move forward and help him to get back on his feet and be a productive member of society. I don't endorse any type of misbehavior, misconduct. I just don't, and he knows that. So I'm that sister that's ready to help him help himself.
Okay, thank you, appreciate it. Okay, I just have one question for you. How old were you when this occurred?
24 years old, sir.
And how long have you been in prison?
26 years.
Out of 40? That was your sentence, 40 years?
Yes, sir.
Okay, yes. Okay, I have no further questions.
I have a question.
Okay, go ahead.
Warden, since he's been with you, what kind of guy you say he is? Tell me that again. Has he made any progress?
So since he's been here, he has not gotten in any trouble. He's joined our Strive program, which means that they have stayed out of trouble. They're allotted more privileges. He lives in our Hope unit. He's employed here as an inmate barber. So during his time at Raymond LaBoy Correctional Center, I mean, he's shown a great conduct and basically done everything that we asked of him. He's now in the new program for Victims Advocate, participated in our Boys to Men program here and completed it without any issues. So in the last 3 years since he's been here, he has shown a positive conduct record.
Thank you, Warden. You guys are doing a good job out there. We appreciate it. Mr. Jermaine.
Yes, sir.
I hope you're just not saying that, if you say, for instance, if you got denied again, are you going to sparrow again, or are you going to keep your word this time on doing what you should do?
No, sir, I'm not spiraling no more. And whatever happens, whatever my fate be today, I'm just happy that I feel good about the situation. I feel good that whatever y'all do, I just gotta, put God first in my life and just keep going. It's a constant battle. It's not nothing that's gonna happen overnight, but I have done what it takes to try to be a better person. And that's why I wanna be. That's not nothing I don't wanna go back to being the old me. I wanna be the new me. I wanna be a success story. I don't wanna be a statistic. I want, and I surround myself around positive people. That's what I'm gonna do when I get out. I want to surround myself around positive. I want to help.
Okay, thank you. Thank you very much.
Okay, the panel ready to vote?
Yeah.
Okay, the panel's ready to vote. Mr. Barrow, it's your case. You vote first.
All right. I think you're on your way there. However, I still got a problem with the way the crime went down. Randomly picking a victim and go and shoot up everybody while they're sleeping. You didn't tell us that part of it when I asked you about the crime. But what really causes me a problem is that since your last hearing, when you were denied partially on your disciplinary, that you got 3 or 4 more disciplinary problems since then. if you could show up over here with no disciplinary problems at all, I think I can vote for you. But today, I got to vote to deny this till you can show up over here with a clean disciplinary record from today till the next hearing, and then I'll vote for you.
Mr. Tillers?
I really appreciate the change you've made. My basic vote today is going to be because of what the warden has said, and in 3 years, I think you've done okay. My vote today is going to be a grant.
Okay. And my vote would be to grant to the parole project for 1 year. I don't think just going there to get your interstate compact. I'd like to see if your disciplinary would improve at the parole project. And then you do your interstate compact and go to Texas and no contact whatsoever with the victim. But he needed a unanimous vote. Okay, you got 2 out of 3. You needed 3 out of 3. So you coming along. You know, don't go spiraling. Do what the warden says, and you'll be fine next time. Okay, thank you.
Huh. I honestly did not think he would get 2 out of 3. Doesn't make a difference. He's not getting out, but that's more than I thought he would get. Anywho, I hope you all enjoyed this morning. I did. I mean, it was started off really heavy. We didn't do as much hopping around courts as we normally do, but a good day nonetheless. Join us this evening, Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. And we will be back tomorrow morning for this show, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. Go have yourselves a great day, and I will see you all soon. Take care. God bless.